All right, this is case number 19-157-158. This is Oakland County, Oakland Community College versus Jacob Hobson. The matter is before the court on a petition for show cause. Do I have someone representing Oakland Community College on the Zoom at this time? Say something if you're there. Do I have Mr. Jacob Hobson? All right. This matter is set on for a show cause hearing after having previously been set for on a subpoena. The plaintiff was required to submit to the court a order for show cause. The court gave this date. I never received the proposed order. Accordingly, the application for show cause will be dismissed at this time. The court calls case number 19-160-060. This is Credit Union 1 versus Tanisha Lawton. The matter is before the court set on for a hearing on today's date regarding a petition for for satisfaction of the judgment in this matter. Record should reflect that a judgment was entered in this case on the 6th of November 2019 for $1,481.46. Subsequent to that time, there was an installment order that was entered as well. Your appearance for Credit Union 1 at this time, please.
Good morning, Your Honor. James Zellin appearing on behalf of the plaintiff, P69241.
All right, thank you, counsel. Good morning to you. I'm looking now for Tanisha Lawton. If you're on the Zoom, please say something at this time. All right, I'm looking for Tanisha Lawton. If you're on the Zoom, Ms. Lawton, please say something at this time. Matter set on for 10 o'clock a.m. It is 9 minutes after 10 at this time. Counsel, any information you can bring to the court's attention at this time?
Your Honor, this matter has not been paid in full. Has not made any voluntary payments. There has been $974 intercepted from her taxes last year and $301 intercepted the year before. At this point, there's still a balance, like I indicated to the court, of $598.85, and a satisfaction of judgment would not be appropriate at this time.
All right, so this started out as $1,421.96 in 2019, and obviously it's been 3 years since that time.
Right.
Give me the payments that you have in fact received.
974 and 301.
All right, and if my math is correct, that would be $1,274. So how is it? I know that there is some interest involved, but how is it that because it looks like to me that the balance under that scenario, at least on the principal amount, would be a little over $200. How are you at 500 plus?
I can revisit that with my client and their calculation of the balance and look at it. But either way, it's not satisfied.
Well, I didn't ask you that. I didn't ask you that question.
Yeah.
We're past that point. You know the question that I'm asking.
Right. I understand. I will revisit this with my client and make that determination, but I'm not 100% sure. I mean, there was court costs in the two garnishments, the interest, but yeah, I'm not. It does the 598 number does seem a little high to me.
Yeah, it seems a little high, but obviously I wanted you to make a record if you could have with regard to. I know that there were other fees that accrue, with the garnishments and so on and so forth. But yeah, if they could do an accounting to try and make sure that you're at the best or at the most appropriate number. If that's a number, that's a number. If not, it needs to be adjusted accordingly. But I am satisfied that the amounts that have been garnished or otherwise paid have not satisfied the judgment motion for satisfaction will be denied at this time. And also, without the benefit of Ms. Lawton being here, she filed a motion. We gave her a notice of this date and she didn't appear. That motion will at this time be denied. Thank you, Counsel. Good day to you, sir.
Thank you, Your Honor.
The court now calls case number 03144-430. This is Palisade Acquisitions number 16, I'm sorry, versus Miranda Brock. The matter is before the court on objections to a writ of garnishment. The judgment in this matter arises out of, the judgment in this matter was entered on the 7th. Strike that on here. That judgment was entered on the 16th of March 2004. The judgment amount is $2,132.82. This writ of garnishment is an effort to collect upon that judgment. I've read the objection to the writ of garnishment. It says I never had that credit card. Your appearance for Palisade at this time?
Yes, I'm here, Your Honor.
I'm looking for attorney for Palisade Acquisitions. If you're on the Zoom, say something at this time. All right, thank you. Now I'm looking for Miranda Brock, please.
I'm here, Your Honor.
All right, thank you, Ms. Brock. This judgment has been in place for about 8 years now, and there have been a number of writs of garnishment regarding this matter. Actually, it's been in place longer than that period of time. Let me just look a little bit further. Hold 1 second. All right. Yeah, the objection that you raised to this matter, ma'am, is not an objection that you could raise in a post-judgment matter. This case has gone on for a number of years, and you can't like 16, 18 years later say, well, I never had a credit card, especially when there have been a number of attempts to collect on this judgment. But you can't. That's a prejudgment. A prejudgment attack that you're trying to use in a post-judgment attack. The only issues that you can raise with regard to objecting to the garnishment is things like I filed bankruptcy, I have an installment order, I already paid the judgment, the funds are exempt, and you don't have any of those reasons. And saying that it was that you didn't have the credit card, you would have had to raise that while the case was yet before the court. So you can't really raise that in a post-judgment matter. Now, there is another problem that I'm seeing with this, though. I see a motion. Let's see what's. Well, actually, I do see that the judgment was renewed in 2014. So the judgment is still valid. What happens is after 10 years, or before the expiration of 10 years, the judgment has to be renewed in order for them to continue to take efforts to collect on it. It was renewed in 2014. Another judge allowed that judgment to be renewed, so it's good through 2024. So the judgment is still outstanding, ma'am, and the defense that you raised, you can't really raise that as a basis to attack this again some 14 years later or whatever it's been. That's you can't do it that way. You could file a motion to set aside the default judgment that was entered in this matter if you wish to try and do that. But that would be the only way that you would be able to attack this matter. You can't attack it. You can't attack the collection effort by saying that the judgment should not have been entered. You have to file a motion to try to get that judgment set aside. Now, the likelihood of you being successful on that is not that great, because again, you should have addressed this issue back in 2004. All right, anything else you wanted to say at this time, ma'am? And then I'll get to one other issue.
Oh, no, that's. Thanks a lot, Your Honor.
Yeah, hold on a second now. Now, so this garnishment is Cadillac products. What is that? Is that where you work?
Yes,
All right, so have they taken any money from you so far?
174 and 136 last week.
Okay, so you get paid every other week? Is that what it is?
Every week,
You get paid weekly?
yes,
All right, so they've been taking like 170, 130 to $170 per week. Is that what it is?
yes.
So your garnishment, looks like your garnishment rate on this is that, I'm trying to calculate. So if it was a 150 a week, you basically $600 a month, perhaps a little bit more than that they would be taken under the garnishment. This judgment is probably, with interest, is probably ballooned to somewhere in the nature of about $4,000 now. All right, so tell me about the $600 a month. Is that something that you want me to leave the garnishment in place, or you want to make a partial payment? What do you want to do now?
How much did you say I owed them all total?
I don't have an exact calculation, but I know the judgment started at $2,100, and it's been years. So that, that judgment likely, it's likely double. But I don't know the exact amount, because interest accrues on these things, and that's what the challenge is here. I was saying that your garnishment is going to hit you for like $600 a month. You might want to petition for a voluntary payment that would be less than that amount. What do you think about that, ma'am?
Yes, that sounds good.
All right. How much do you think you can afford? How much do you think you can afford to pay on this?
Well, I would like to pay like $50 a week.
All right.
Because I have a lot of other bills.
Yeah, that's what I was getting ready to ask you about. Do you pay a mortgage, or you pay rent, or what?
I pay rent of $875, and then I have Comcast, and then I have my lights and gas.
Okay. You have a car note?
No.
Okay. All right, ma'am. So what I'm going to do, I'm going to set your, because the garnishment will take $600 plus a month. I'm going to go ahead and set your payment at $200 a month, and I will stop the garnishment under those circumstances. Any funds withheld will, in fact, be released to the plaintiff in this matter to go towards the judgment. But then I will stop the I'll stop the withholding, or suspend the withholding, and I'm going to allow you to make the voluntary payments. So $200 a month, and I'm going to commence that on September the 2nd. September the 2nd. So you'll get an order from me.
Okay.
Requiring that you pay $200 a month, beginning on September the 2nd.
Okay.
And as long as you make those payments, then your wages, wage garnishment will be suspended. But you got to make sure that you make that payment every month. You understand?
Oh yes, I will. So you saying just pay $50 a week to them?
No, you're gonna have to set it up. You're gonna have to set it up in such a way where you pay the $200 once a month. So that's why I'm giving you until September the 2nd. So September the 2nd, you want to send to this company. It's on your documents to the Chevette law. You want to send them $200. And when you get to October, the first Friday in October, you want to send $200. So that's what you got to set it up that way. You understand?
Okay, that sounds good, Your Honor.
All right. I'm glad that works for you, ma'am. And you'll get an order from me. Take it to your payroll department, and they will stop garnishing you. Understand?
So you say, wait for your paper and then, take it to payroll and they'll stop garnishing me?
Yeah, I'm gonna get this in the mail right away, so you can
Oh.
take it to payroll. This is an order for them to stop garnishing your wages, okay?
Okay, and then after they stop garnishing my wages on October, you said, make sure that I pay, do I call them and make, arrangements to make the $200 payment?
Yes, ma'am. Or you could just drop mail to the Shemetta Law Firm, okay? You're gonna get an order from me that allows you to make those payments, okay?
Oh, that sounds good.
All right, you'll get some paperwork from me. It'll explain it in more detail, ma'am. I wish you well. Good day to you.
Okay, good day. Thank you, Your Honor.
All right, thank you.
Bye-bye.
And then I'll let you.
Okay.
Appreciate
So,
it.
is this what you want me to put your file
Yes.
that I picked up?
Yeah, yeah, yeah.
I came in this morning.
Hold on again.
Yeah, I came in, just checked in with Deborah.
She's okay, right?
She said she went done with it, so.
She used to tell me something, so I hope she's okay.
So if anything you need, I'll do it at my desk, okay?
Okay.
Let me finish my vote in this basket. You have a lot of files.
What's done over here? Wait, you said I have a lot of.
You got a lot of files downstairs.
Well, bring them up.
I did. Here they go. It's all of them. All right.
That's what we get for.
So anything that you need, just call me
Gotcha.
and I'll come right up. Okay? All
All
right.
right, real good.
Thank you. Have a good day, Judge.
You likewise. All right, the court now calls case number 21-24-1271. This is Lakina Abrams versus Dana White. The matters before the court are the motion to set aside a dismissal and for reinstatement of the cause. The court took the matter under advisement and set it for a virtual hearing on today's date. Your appearance for the plaintiff in this matter, please.
Yes, Your Honor.
What is your name, ma'am?
Lakina Abrams.
Thank you, Ms. Abrams. For a defendant in this matter.
Good morning, Your Honor. Coleman Pods P7607 on behalf of
All right,
defendant.
All right, thank you, Mr. Potts. All right, so Mr. Potts, did you get the petition for reinstatement of the of this matter, sir?
We did not, Your Honor. I just got notice of the court date.
Okay. The note that I have says I was out of state attending a family medical emergency. My presence was required, which created a conflict of and rendered me unable to log in and attend the scheduled hearing. Only the court took part in my absence and grant me mercy and set aside dismissal. Allow me to opportunity to have my case heard. Thank you for reconsideration. Counsel, what do you have to say about that, sir?
Was there any proof attached, Your Honor?
I'm sorry, say that again, sir.
Was there anything attached showing she was out of town, Your Honor?
No, there were no backup documents or anything, but that's the that's the full extent of the motion that I received, Mr. Potts.
Well, I'm going to object without argument, Your Honor. And if the court is inclined to set aside the dismissal, just ask for $250 in costs.
One moment. All right, ma'am. So tell me, Ms. Abrams, about this out of town situation. Basically, what I'm looking for is why didn't you call the court, ask for an adjournment, contact anybody, send any written document, make any request whatsoever to have a new date prior to going out of town, on your way out of town, any of that? Why?
Yes, Your Honor. I'm actually a guardian for my grandfather now. We recently lost my grandmother. She died. And so my grandfather is now, he has some medical issues. He's now in first stages of dementia. And so they have an adopted daughter. You know, she was 6 months old when they moved away from Detroit and moved to Virginia, bought a house. But now, like I said, my grandfather has dementia. The young lady now is 22. She graduated from college in Virginia. So we flew my grandfather with some care aides to attend. But my grandfather, along with the adopted daughter, she was moving off campus as she has graduated, and she needed to get her things out of storage. And why we decided to keep my grandfather there to stay on after, you know, the graduation. He has some medical issues, you know, that he's been dealing with that we did not know about because none of these things were disclosed to us. But he had to go to the hospital. We were still in Virginia. We never left. So during that time where he had to have a procedure, myself and my husband, our guardians, we needed to be there. And during that time, it came back to my mind in my book that I did need to attend a hearing, but we're in Virginia, there's mountains, there's trees. So at that time, it was important for me to be there for my grandfather, along with with his daughter, his daughter. And so immediately when we were able to drive back home, I did rush downtown to try to, you know, I wanted my case to still be heard. So I just wanted to have mercy in that case, because like I said, if we were dealing with a family issue, we don't have crisis all the time, but I didn't want it to be excused, but just wanted you guys to be able to hear my case and just, you know, I guess use the court discretion but at least grant me some mercy, because I planned on being there and attending, you know, the hearing. Even like I said, it was virtual, so it would have been convenient, but I just, during the circumstances, I was unable. I just had to make a decision, and I chose, you know, to be there for my grandfather.
All right. So when it comes to court dates, of course, missing the court date is quite consequential, and you have a lot of things going on, and they all seem to be very, very valid. But you have a small window for not appearing in court, because you can make a phone call and so on and so forth, and you can do that in advance, and you can even do that in real time, and it's easier to do it that way. But I do believe that the issues that you have submitted to me are enough justification for the court to set aside the dismissal. So I will set aside the dismissal. Counsel, who is being paid by his client, has to make this appearance, and so he's asking the court to award costs. What I'm going to do is I will set the matter aside. I'll take costs under advisement, and I will address that as this case proceeds. I will set the matter over. Counsel, is there any reason why this matter is not ready for trial, or what issues need to be addressed prior to this matter being presented for trial?
Trying to see, Your Honor, if we participated in any discovery in this matter. I think I saw some discovery responses.
I didn't hear you, counsel.
So I was trying to figure out if we already participated in discovery in this matter. I don't see a scheduling order in the file, so maybe we need a short period of discovery before we move forward with trial.
Yeah, I don't see where the court scheduled anything by way of discovery. Discovery is the process of the parties exchanging information that may be under the control of another party for purposes of trial preparation. Well, let me ask you, first of all, to Ms. Abrams, is there any information under the control of the defendant in this matter that you would ask be turned over to you? Is there anything that you're seeking, any information that they have, any questions that you want to ask of them prior to trial, so that you'd be prepared for trial? Anything that you would need in that nature?
Well, there is a video. When I was at the salon, they had a videographer that was there that actually saw the process of my hair. And so I was unable to reach that person, and I didn't want to interfere. So there was video, because there's still video of my pictures and my hair on her website or social media. So if I could have access to that.
All right, I'll order that that the video, what date was it, if you recall, that you were there, ma'am?
July 28th of 2021.
All right, that any and all videos, pictures, images that relate to events arising on July 30th, 2021 be forwarded to Ms. Lakina Abrams within the next 30 days. All right, Council, anything that you're requesting of Ms. Abrams, are you interested in maybe going interrogatory, something like that?
Yes, Your Honor, probably do some interrogatories, request to admit, maybe some requests of production of documents.
All right, so Mr. Potts is going to send you some discovery items that are going to be the nature of questions and a request to admit and maybe some other forms of discovery. And you'll be required to answer them. Typically, once you receive them, you have 28 days to answer those documents. So he's going to get them out to you in short order so that you can get that done. Essentially, what I'm going to do is I'm going to allow for discovery between the parties up till the date that I'm going to give you. That will give you time to get out, to send things out, and to get answers back. And then we'll have a pretrial conference for the court to decide where the case is at that point and whether it can be resolved, whether or not it needs to be a trial setting. So your next date to come in front of me is going to be the 29th of September. So 9/29, 22, and that's going to be at 9:45 a.m. You have a pretrial conference date. You will get a order from me saying that discovery is open through that period, and also establishing that as your next date to be back in the zone. That order will also be an order reinstating the case and taking the issue under advisement regarding request for cost of this matter. Okay. All right, so I wish you well. You'll get the document from me. Note the date again, November 20, strike that, September 29th, 2022, 9:45 a.m.
And Your Honor, sorry to interrupt. I don't have a copy of the complaint. If Ms. Abrams could share a copy of the complaint with me as well.
All right. Well, what I'm going to do is I'm going to go ahead and have my clerk, when she mails out the notice, when she mails out the scheduling order, I'm going to have her go ahead and send you a copy of that document, Council. So
Thank you, Judge.
there's a 2-page document, so I'm going to make sure that you get both of those pages, just in the interest of expediting the matter. All right, so we'll take care of that. All right.
Thank you, Your Honor.
Thank you to both of you, and I'll see you in the near future. All right.
Yes, sir. Good day.
Case number 16-126139. This is Marlin Financial Services Corporation versus Brandon Flanagan. The matter is before the court on the filing of objections to a writ of affidavit, a writ of garnishment, I should say. There's also attached to that a motion petition for installment payments. The record should reflect in this matter that judgment was entered in this case on the 12th of May of 2017. That judgment is $6,830. Do I have Modern Financial, your appearance from Modern Financial, anybody representing Modern Financial on this Zoom, say something at this time? Do I have Brandon Flanagan on this Zoom?
Yes, sir, I'm here.
All right, good morning to you, Mr. Flanagan. I have received your objections to the writ of garnishment as well as your petition for partial payment. And looking at your objections, you indicated I was not served no papers in this case from anyone, no court date or anything. That type of objection, sir, is not one that the court can rule upon in a post-judgment matter. If you believe that you were not served in this matter, then you would have to file something in the nature of a motion to set aside the default judgment, and it was entered as a default judgment. And I have notations that says on the summary of action, it says that you were personally served the documents on January 29th, 2017. And so the file would have something in there suggesting that. It also, I see where at one period in time that this case was stayed due to bankruptcy petition. So at one point you filed something in bankruptcy, is that correct, sir?
Yes, and I was it wasn't my car, but I co-signed for the car, and the person who car was had filed bankruptcy, and then it came back on me. So when I went to court, that's when I was working my last job. I just went ahead and just started. We made a payment arrangement, but then like a year and a half, 2 years ago, I lost my job due to COVID. Then I stopped working, and then I ended up breaking my foot, and then I just started back working. I just completed my 90 days. And on my 90-day check, that's when I got the garnishment took out. I didn't know that they was going to take it out because I would have got back on the payment plan that I was on.
Yeah. Yeah, I see where there was a payment plan. I see where that was ultimately set aside when the payments, when you didn't keep up with the payments. Yeah, so I mean, you passed that point really where where you're able to object to the on the basis of not being served the papers because you kind of already started paying on this. And so the objection, I would have to find that the objections are not valid in this matter, and that so I'll have to deny the objections. But I do see your petition for installment payments. Now you said that you were garnished recently. How much did they? How much was that garnishment? How much did they take?
My last check, they took $640. I had worked like 14 days straight, and they took $645. My boss was letting me get caught up on my rent because I was behind, and he let me work 14 days straight. I did 140 hours, and then when I got my check, they took $645.
Okay. Wow. Yeah, they got you.
Yeah.
All right, yeah, so it sounds like then that, well, I know that's a lot of hours of work, but it sounds like you would be hit with a garnishment, and your garnishment rate would probably be about $200 a week. Well, maybe 150, 175 if you work it normally. So that it's a heavy garnishment one way or the other.
All right, 'cause I still paying. They taking child support out, and then I got my rent, DTE.
How many kids you have on the child support?
I have 3 on child support, and I'm garnishing for 2 of them, and I'm just paying the back fee on 1.
You ain't got no money there.
And it's been rough. That's why I said I just started back working. That was my 90th day. I got hired in. I work at Domino's, so it ain't like I make a lot of money unless I do a lot of hours.
Gotcha. Yeah, all right. So how old are your kids?
I have a 20-year-old, I have a 16-year-old, 15-year-old, and at home I got a 7 and a 3-year-old and a 2-year-old.
Okay. All right, gotcha. All right.
And I'm paying like 30. I ain't got no vehicle right now, so I'm paying like $30 to get back and forth to work every day. My job in New Boston. I live in Detroit, so it's like a 30-minute drive through a Lyft.
All right. Well, I was thinking that an amount a bit higher than the $100 a month would probably be more reasonable, given the fact that this judgment has been around for a long time and that interest is still accruing and so on and so forth. But it sounds like to me that you probably can't pay more than $100 a month. So I'll leave it at $100 a month. And I'll suspend the garnishment in this matter, so long as you make the payments on the,
Okay.
on the partial
I had a
payment.
question, like the money that they took already, would they be able to release that back to me after I start my new payment plan? Or,
You're not gonna get that money, you're not gonna get that money back. That's gonna go towards it.
okay,
And I'm hoping that they won't get a chance to garnish you again before payment plan kick in. So I'm gonna sign the order to stop it. I'm gonna get that out to you in the mail right away, so you can take it to your payroll, so they can stop the garnishment. They may hit you again. So I'm gonna go ahead and set your $100 payment for September the 9th. So you'll make the voluntary payment September the 9th. That give you some room just in case they hit you again for another garnishment before that time. But my order is gonna stop the garnishment. So
Okay.
you get that, as soon as you get that from me, you wanna take that to your payroll department, because they'll have a court order to stop it. But if that order don't get there before your next pay, then they're gonna get you one more time. Understand?
yes. I had another question, like they put a lot more money on it than what it was. I was wondering, could they excuse the late fees because I wasn't working or anything like that?
Well, there's not anything that I can do about that, because that's what you call interest. So when a judgment sits around for a while, it keeps accruing interest on it. And that's, I'm looking at their saying that it's in the nature of $8,000 now, because there was no payments for a while and interest was accruing on it. Sometimes what can happen is that, you can reach an agreement with the other side with a way to pay it off by a certain time, and then they'll waive the interest and so on and so forth. So you have to work on that. But for right now, the best you can do with it right now is to get this down to like that 100 a month. Just keep it up off of you until you can position yourself to do something different.
Okay.
All right, so that's how I'm gonna set it up, Mr. Flanagan, and you'll get two documents from me. One is an order for installment payments starting September the 9th, and then the other will be denying the objections, but stopping the garnishment.
Okay.
Which, if you get that garnishment up off of you, that's gonna save you some problems, all right?
All right.
All
Yeah.
right, so I'll get those two documents out to you right away, sir, and I wish you well, all the best.
Okay. Thank you. You too. Have a good day.